Hi, I'm Nederlandse Spoorwegen,
Actually, it's pronounced Nederlandse Spoorwegen.
the principal rail company in the Netherlands. With my friend NBS, the National Belgian Railway Company, we wanted to connect Amsterdam to Brussels with a high-speed rail service called Fyra. When it came to developing the project, we first looked for a high-speed train manufacturer. Our options were Alstom, Siemens, and AnsaldoBreda.
Hi, let me present myself. I'm AnsaldoBreda, the Italian train manufacturer who won the 336 million contract for the Fyra project because we could offer the fastest trains, 250 kilometers per hour at the lowest price. In 2004, we signed a contract with NS and NBS for the delivery of 19 V250 trains for 2007, 16 for the Dutch, and 3 for the Belgians. After a couple of years,
many years of delay.
as I was saying, after a couple of years, we finally started delivering some trains to NS.
In December 2012, operations were finally able to commence with the first 9 trains we received and paid for. However, within the first month of the service, we were already experiencing problems and delays. Indeed, we quickly realized that the trains were not manufactured to the standard we were promised. The quality was insufficient. Corrosion and rust were spotted in multiple places, and there were loose parts at the bottom of the trains. There was a risk of snow even leaking onto electrical components, and the irony of it all, the brake system was not appropriate in winter for the speeds that they promised us.
Whoa. Hold your horses. Don't throw accusations like that. The breakdowns were due to your operational mistakes in cold weather. If you continue, we're going to sue you for reputational damage.
Those are empty threats. As you might have understood, on the 17th of January, 2013, we decided to stop the service for the safety of our passengers. Our Belgian friends went to even more extreme measures by halting the Fyra project entirely and refusing to receive or pay for their 3 trains. We were furious as well. We want to rescind the contract and get back the 213 million euros we paid in advance.
And on what basis?
You breached the contract by delivering unacceptable products, and for that reason, we are allowed to terminate the contract.
Who says that?
The law.
I want proof.
Oh, I've got proof for you. Which one do you want to choose? Unidroit, Dutch law, the United Nations contract for the international sale of goods, or your beloved Italian law? They all give me the right to terminate the contract.
That's a bit far-fetched. You can't use all these laws.
Actually, if you had any legal knowledge, the EU law states that parties have the freedom to choose the applicable law to the contract. And since our viewers don't know which law governed our contract, allow me to give you a few choices. Why don't we start with Unidroit? Have you ever heard of Article 731 about the right to terminate a contract? Let me jog your memory a bit. A party may terminate the contract where the failure of the other party to perform an obligation under the contract amounts to a fundamental non-performance. I'm not done. Because I'm sure you're going to ask. The article describes a fundamental non-performance as something that substantially deprives the aggrieved party of what it was entitled to expect under the contract unless the other party did not foresee and could not reasonably have foreseen it.
Aha! Are you going to give us the benefit of the doubt and think that maybe we had no idea about it?
I'm sure you don't think your trains could have been that bad of quality, but you could have for sure tested them before sending them over. I mean, I think that everyone will agree that unusable trains are a fundamental non-performance in this contract.
I'm not convinced.
Oh, you're not? Well, let me help you. Let's move on to the CIGS. Article 35 states that the seller must deliver goods which are of the quality, quantity, and description required by the contract, and which are contained or packaged in the manner required by the contract. They clearly were not of the quality required, so you did not fill your part of the contract.
Maybe we didn't, but you are supposed to give us the time to repair the products, according to Article 46. We could maybe possibly propose a plan of repairment in 2 years.
2 years? Are you joking? How could you possibly think that is a reasonable time? We truly aren't convinced by anything you propose anymore. Further, Article 49 states that the buyer may declare the contract to be avoided if the seller's failure to perform obligations amounts to fundamental breach of contract.
Who said we breached the contract?
Really? When will you ever understand and admit you're wrong? According to Article 25, a fundamental breach of contract is something that substantially deprives a party of what they were entitled to and expected under the contract, unless the party in breach did not foresee and a reasonable person of the same kind in the same circumstance would not have foreseen such a result. Do you really want me to ask a stranger if they would not have foreseen such a result?
No, thank you.
You know what? Let's continue with Italian law. Maybe you will agree with that one. Article 1453 of your Codice Civile states that if a party faces persistent non-performance after fulfilling their part of the contract, which we have, the party can request performance or termination of contract. And as you guess, we request termination of this contract.
What about your beloved law?
Ah, finally, an interesting remark you make. Well, our law just confirms it all. Article 7.21 says that if there is non-performance because of a lack of conformity, the seller must repair or replace the object if he or she is responsible for the defect. You have already confirmed that you can't do that in a reasonable time, and so, if this is impossible or cannot be expected from the seller, as in our case, the buyer remains fully entitled to claim damages, to withhold payment of the purchase price, or to rescind the sale agreement.
Okay, I got it. Look, we both don't want this to become a long and expensive legal battle. So, why don't we settle the case?
I agree. Give me my full advance back.
Come on. Be reasonable. You know I don't have the funds to do that. What I can offer you is 125 million euros as a refund for the 9 trains you returned to us, and we can agree to share responsibility.
Share responsibility? You know, you are most likely responsible for the defects of the rolling stock. But you know what? I don't want your trains, nor to deal with you anymore, so we'll accept the settlement offer.
We might have lost some of you by now, so let me do a small recap. Because of the freedom of contract as stated in the Rome I Treaty, we are not sure which law the two parties used. However, after careful examination of the Dutch law, the Italian law, the CIGS law, as well as the Unidroit principles, it is clear that if this case had been decided by court, NS would have been entitled to rescind the contract and most likely gotten some monetary compensation. However, the parties decided to settle the case in March of 2014 because they feared a lengthy legal battle that would have ruined AnsaldoBreda. Moreover, the Italian government was one of AnsaldoBreda's key shareholders, meaning that a lawsuit would have led to political tensions between Italy and the Netherlands. The lesson to be learned from Nederlandse Spoorwegen vs AnsaldoBreda is to test products before delivery, inspect products after they were delivered to you, and never buy the cheapest, fastest train.